Good morning. Honorable guests, my dear friends, ladies and gentlemen, it gives me a great pleasure to welcome you to the Third International Arbitration Forum in Athens, which finally brings us together in person for the first time since 2019. The event was originally scheduled to take place in October 2020. Back then, Stavros and I were tempted to hold the conference virtually. However, we both considered that an event which aims to serve as a platform for intellectually stimulating discussions requires physical attendance and face-to-face debates. Our wish was to give the opportunity to all attendees, arbitration practitioners and academics alike, to meet with each other. I believe our decision to wait was right. And I'm grateful that we meet all in person today for this forum as part of Athens Arbitration Days. This is indeed a very busy week for the Athens-based arbitration community. The past 2 days, 2 events took place, organized by the ICC Young Arbitration ADR Forum and ICC Hellas yesterday, and tomorrow an LCIA event is scheduled in which the latest LCIA rules are to be presented. Today in this forum, we will address the pervasive and often complex topic of mandatory rules in international arbitration. It is tried that arbitration is subject to the overriding principle of party autonomy. In this respect, arbitration starts, develops, and concludes primarily as per the common will of the parties. This is true regardless of the various national laws regulating arbitration. Recourse to arbitration always requires the consent of the parties evidenced by the arbitration agreement. You may have noticed that I use the word primarily when I noted that arbitration is the byproduct of the autonomy of the parties. This was intentional, of course. The various legal orders, in order to ensure that public interest is served, have introduced mandatory rules which aim to control certain aspects of the arbitral process and to which, as a result, the party autonomy is subordinated. One may nevertheless wonder how this reconciles with arbitration, which, as said, is the byproduct of the autonomy of the parties, which are free to choose the submission of their dispute to arbitration, the arbitral procedure, and can even determine the termination of the arbitral proceedings. The positions taken on the matter are, as we all know, diametrically opposite. During the 20th century, prominent academics and arbitration practitioners have posited that arbitration as a byproduct of party autonomy does not hinge on an individual national legal system. Instead, international arbitration generates and evolves as a freestanding system independently of the apparatus of the state or as a mechanism transcending national legal orders. As a result, this approach, international arbitration, does not find its underlying source of legitimacy in the rules of a specific state's legal order, but only in the agreement of the parties. The above position taken by Charalambos Fragistas, who first shaped the notion of arbitrage supranational, by the late Emmanuel Gaillard, who shaped the notion of the autonomous arbitral legal order, and the relevant views subsequently expressed by many others, among them also by Julian Yu, are compelling. However, one may not disregard the fact that the autonomy of the parties is neither self-efficient nor self-standing. It depends on the recognition by a national law namely the law to which the parties have subjected their arbitration agreement or the law of the country where the award was made. And this is not a matter of ideological predisposition, but as a matter of positive law, namely the New York Convention and the UNCITRAL model law. Along the same lines, states place some limits on party autonomy when certain matters are declared non-arbitrable. The limitation stems from the lex fori of the country where the award was made or the country where the recognition or enforcement is sought. Concerning the parties' agreed arbitral procedures, limits are also placed in view of the procedural requirement laid down in all leges arbitri of equal treatment of the parties and the right of the parties to be heard. This is also stipulated in the New York Convention, indirectly. There is also the control function of the state courts, which respect to the validity and the binding effect of the arbitral awards. This is entrusted to the state courts of the country where the award was made and of the country where the recognition and enforcement is sought. The control functions provided by national courts extend also to the arbitrator's independence and impartiality obligations, which stem from the mandatory rules of the country where the arbitration took place. All the above have been thoroughly discussed among commentators and may be considered as a classic debate that has long been resolved with nothing new to offer. In relation, however, to the topic of the present forum, the debate is not over. There are still open issues regarding the application of overriding mandatory rules in international arbitration, be it the mandatory rules of the lex contractus or of the lex fori of the country where the award was made or of the place of recognition and enforcement. For example, the relevance of the Rome I and Rome II regulations to international commercial arbitration and the application of mandatory EU provisions by arbitrators has triggered heated debates among commentators. Some of them have advocated against the arbitrator's obligation to apply the EU regulations, positing that EU regulations are binding only on EU courts and not arbitral tribunals, that the arbitrators, as private judges, shall comply only with their mandate as defined by the parties and are under no obligation to apply any state law other than the one chosen by the parties on the basis of the party autonomy principle, or failing such designation, the one considered applicable by the arbitral tribunal. This position, including the one which considers overriding mandatory rules as persuasive authority without any obligation for the arbitral tribunal to apply them, are to be outright dismissed as extreme. In my view, the international arbitration community should come to understand and appreciate the justifiably increasing interest of the states to defend their fundamental values and rules by even blocking phenomena that undermine such public interest within their jurisdiction. In case the arbitral community fails to promptly respond to this need, the states will certainly seek to introduce even stricter legislative measures to secure their interests. Such measures could potentially obstruct the further development of international arbitration. Besides, as CJCU's rulings in EcoSwiss, Mostaza Claro, and Astrocom reveal, the arbitrator's failure to apply or even to apply correctly overriding mandatory rules may hinder the enforcement of an arbitral award on public policy grounds, either within the jurisdiction where the award was rendered or within the jurisdiction where enforcement is sought. The very complex and interesting topic of overriding mandatory rules in international arbitration we will examine today during the course of the keynote speeches, interventions, and discussions to follow, which will be delivered by some of the most prominent colleagues and leading authorities in international arbitration. I'm confident that by the end of this day, we will have gained a better insight and have enriched our knowledge on the subject matter. That said, I would like to deeply thank all those that will contribute to the scientific success of this conference. Had it not been for them sparkling the scientific debate on such pervasive topics, international arbitration could not have further evolved. I want to thank and express my gratitude to Sakoulas Publications, especially my dearest friends Panagiotis Sakoulas and Yannis Papagrigorakis, who made it possible for all of us to meet here, and of course our sponsors for their vital contributions. Finally, I want to warmly thank my dear colleague and friend Stavros Brekullakis. It is an honor coordinating the Third International Arbitration Forum with Stavros. Holding this conference was only possible through his commitment of time and effort. Thank you very much.